Welcome to Grow Money Business, the podcast dedicated to helping business owners grow both their wealth and business on their own terms. Here's your host, Grant Bledsoe.
Hello, everybody. Grant Bledsoe here. Welcome back to Grow Money Business. This week on the show, my guest is Hannah Shakin. Hannah is an attorney with Downey Brand here in Sacramento and has a law practice where she is focused on estate planning and probate and trust litigation. She was an excellent guest. She joins me on the show this week, and we talk about everything estate planning for business owners and digital estate planning, which has evolved a lot in the last decade, as you can imagine. And what that means is after you die, what happens to your social media accounts and your pictures and your music? Who can access them? How do you set things up to make sure that your spouse or whomever else you want to have access can actually do so? And what are the legal frameworks we need to be aware of as forward-looking planners? Hannah is really sharp in this area. We had a great conversation, and I hope you enjoy it as much as I did. Hey everyone, I need to interject quickly to remind you all that nothing found in today's episode or any other episode of Grow Money Business should be considered financial, investing, legal, tax, fitness, or even relationship advice. It's content that you're free to use and to deploy on your own terms. And before taking any actions on content found on the show, please do consult with your tax professional, your attorney, or your financial planner. If you don't have a financial planner, head on over to threeoakswealth.com to learn more about what we do in terms of financial planning and investments and how we help clients on an ongoing basis. Hannah, thank you for joining me. It's a real pleasure to have you on the show. I appreciate you being here.
I'm so excited to be here. Thank you for having me.
So you focus your career and your legal work in an area that overlaps with my job a lot. Could you describe what your practice looks like in the firm in which you practice?
Absolutely. So I am an attorney in the estate planning department at Downey Brand. We're a firm based in Sacramento and throughout California with about 100 attorneys and some diverse practice areas. But I myself am a certified specialist in the area of estate planning, probate, and trust administration, which is a really wonderful honor given to only about 2% of attorneys, which means I don't dabble in other areas. I exclusively do estate planning, meaning you are living and we're working to create an appropriate plan for your assets, for your family, or estate administration, usually meaning a person has passed away or maybe they've become incapacitated and it's time to carry out their wishes. So I'm working with their trustee or their executor or other named individual, or if no plan exists, then with their family to carry out their estate.
Very cool. How long have you been practicing?
8 years.
8 years.
Yes, in the Sacramento area for 7 of them, originally in the Bay Area, but moved up shortly after graduating law school.
Gotcha. Does it feel like 8? Is it going faster or slower than you would have guessed?
Oh, great question. That feels about right. 8 years feels about right.
So our podcast show, as you know, we have this financial planning firm. We work with a lot of business owners, and this podcast is meant to be a show to help business owners organize and structure their business and personal finances in a way that aligns everything together in a way that's congruent with their long-term wishes. And there's a lot of meat on that bone. There's a lot of stuff going on in the business. There's a lot of stuff going on personally. And one of the things that I wanted to get your thoughts on is digital estate planning. We've had a couple different estate planning attorneys on the show over the years. And I think our listeners have a general feel for everybody needs a will. Oftentimes you need a living trust, especially if you live in California and you own a house, you probably want a living trust. But now more of our assets are online. And concepts like what happens to our social media accounts, what happens to our email accounts. I know that there is some broad legislation that kind of governs that. Could you maybe paint the picture for what the landscape of digital estate planning looks like today?
I'd be happy to. I am going to rewind for just a moment and talk about what it looked like before the new bill in question, just so we have a baseline. Prior to the law that's in place now, which is sort of happily known as RUFADAA, which I'm sure we'll explain a little bit more. Prior to that,
Sounds like a party drug.
It does. So the RUFADAA, prior to that, you were subject to the terms of service. So when you logged onto a site and you created an account and you clicked accept, and maybe you read, maybe you didn't read, that was the language that was going to be applied to you, period. Meaning it didn't matter what your business documents look like. If you had an agreement with your business partner that you were going to share this account, it didn't matter if you had a will in place that said, I want my executor to take over these things. If the terms of service says, when this person passes away, this account locks down and no one else can access these assets, then that was going to apply, period. And almost all of those terms of service did. So what was practically happening is individuals were, maybe leaving a sheet of paper with their estate planning documents that said, here's my login, here's my password, if there was anything of particular value online. And maybe practically that worked, but technically that's illegal. Technically, that's even if you've given permission to your spouse to enter into your accounts to get all your photographs or your whatever, it would have been hacking for that person to use your information. So obviously that was a problem. As we are a more online society, we needed a plan for, who's going to get my photographs that I store online, or my, access to my bank account that I store online, or, lots of people now have a valuable social media presence. Who's going to get access to that username, to that YouTube channel?
Can I interject real briefly?
Of course.
So practically, that's what, when we start the estate planning discussion with clients in the firm, we ask people questions like that, and over and over and over again, we say, well, I've got all my passwords and usernames in a spreadsheet. My spouse knows how to get them, right? And so realistically, before this law that you'll get to in just a minute, was anybody ever being challenged on that? Was anybody actually being charged with fraud for accessing a deceased spouse's social media account?
So I couldn't find any examples in that situation. If it was truly part of a more nefarious, I'm logging in to steal money, which does sometimes happen in families, they would use this law to capture wrongdoers. But the government wasn't bringing charges against, a grieving spouse for inadvertently using something they shouldn't have been using. The issue was, let's say you mistyped the password and got locked out, or you used one of those storage programs and then later couldn't get access to it. You didn't legally have authority to. So even though you had the username and the password, if you didn't have everything you needed, let's say the phone to do the dual authentication, or the, your favorite cat's name to get past that barrier wall, you couldn't call up the company, you couldn't call up Facebook or Google and say, I really am supposed to be accessing this. I have the password, I have the login. You couldn't assert your rights because you didn't have any rights.
Sure. Because they're just going to tell you to pound sand. That's not part of their terms and conditions.
That is exactly what would have happened.
Got it. Okay. So that's why we needed a law. And what happens next?
Sure. So the very brief history is, initially what was introduced was the Uniform Fiduciary Access to Digital Assets Act, which was UFADAA. And UFADAA was created without tech companies weighing in. And so it was very generous. You could use a trust to give authority to a trustee, a will to give authority to an executor, a power of attorney to give authority to an agent. And I can certainly explain all of those if you'd like, but for the moment, we'll stick with everything was handed to those individuals. All of your message history, all of your everything that existed in these online accounts. UFADAA was adopted by exactly one state before the tech companies got their lobbyists to absolutely destroy it. So the tech companies swung back the other way, introduced a proposed law, which I think would be pronounced PEACE. It's PEAC, the Privacy Expectation Afterlife and Choices Act, which swung all the other direction of the executor has to have authority from the court, and the court has to say specifically what the executor can access. And if I, the tech company, don't like it, I can actually say, nope, I'm only going to give you X instead of X and Y. It was very restrictive, very cumbersome, was adopted by none states. And so luckily, as a reaction, the tech companies and the policymakers came together and made RUFADAA it was the revised Uniform Fiduciary Access to Digital Assets Act. And that was the middle ground. You can give authority, it's somewhat limited, but you can kind of specify within there so that tech companies were more comfortable because users can say, I do give authority to photographs, but I don't give authority to messages. And it made their life a little easier where they were less at risk of giving away something that they shouldn't have been and becoming liable.
Sure. Okay. So this policymaking that we're talking about, that's happening at the federal level, right? And then the states have the choice of whether to adopt that uniform code or not. Is that right?
Correct.
And so how does that work in practice? I mean, why would realistically, why would legislators at the national level go to the trouble of passing this legislation without getting input from states in the first place? I mean, it seems like wasted energy and wasted time if you don't get buy-in prior to the draft of the legislation, no?
That is a really interesting question. I don't know a lot about the history. So the institution that's doing this is called the Uniform Law Commission, and it is a group that creates these proposed legislations that they do expect to be adopted by some or all of the states. I mean, for example, the RUFADAA is now adopted by almost every state. So their work is, the Uniform Law Commission is very impactful, but I don't know what their motivation is for doing that. They obviously put a lot of work into the UFADA, and only one state adopted it. So sometimes they win, sometimes they lose. Great question.
And this, I have kind of an unrelated follow-up question. This method of creating laws that's how a lot of laws are created at the state level too, right? Because we have the Uniform Probate Code, which I have a couple questions about for you, and a lot of other laws are passed at the national level. States have the choice of whether to adopt them or not.
Correct.
Could you maybe explain what the Uniform Probate Code is? And I'm also curious, California is one of the few states that has not adopted the Uniform Probate Code, and I'm curious why the state chose to do that.
Sure. So, as a little bit of background information, when a state adopts this uniform, whichever code, whatever the code is in question, they are permitted to make changes to it. So, the first thing I would want any listener to understand is the uniform code is actually not uniform from state to state. They're very similar in almost every case, but it is, taking the educational piece, the research, the effect, doing the case studies into a main governing body and making sure that they're weighing all the pros and the cons, or attempting to, and then releasing something to the states with the hopes that some or many of them will adopt them. But no, California's probate code, again, there's a decent amount of crossover, but it is unique to California. And I don't know the history of why that would be.
I always just thought that, or I guess I always assumed that it was because California is a very zealous blue state, and maybe that's the reason that they might not want to do what the rest of the union is doing. But then you see this also with like traffic laws, and as I recall, we have this interstate system, and in order to have some uniformity between like speed limits state to state, I think that didn't the national government promise a whole lot of funding for roads and infrastructure, but in exchange for having some consistency in the rulemaking?
Exactly. So they can motivate you to adopt their laws, but they cannot force a state to adopt their laws. So yes, with that, there's a lot of money on the line if you agree to these speed limits, but they cannot force a state to adopt any law.
Got it. Okay. Am I correct in putting that kind of stuff in the same bucket as RUFADAA as far as policy making, and then whether the states have the choice to adopt or not?
Yeah, absolutely. I think that RUFADAA was unique in that it was so modern that no state had anything comparable. For other laws, I think timing is an issue. If the state has already tried out a few options, then they kind of know what works for them or doesn't, or what their policy um, policy motivations are, whether it's tax or other money making for the state. But RUFADAA was groundbreaking, and so all of the states, instead of saying, "Well, we're going to create our own," they jumped right on board.
Gotcha. Before I get too far off on a tangent, let's bring it back to where we are today. Thanks for bearing with my stream of consciousness, rapid fire questions. So, what are the elements of RUFADAA that we care about? What is the landscape like today, given that rule that has been adopted by most of the states? All the states?
Question. So 49 at last count. I believe it was Massachusetts that wasn't on the list I had in front of me. I wanted to look into why, but I didn't. I probably will after this. So if we want to do a part 2, I will come with that information. So California, there was kind of a first swing of a lot of states who jumped on board. Then a lot of states that had tech company presence had a harder time passing it. And so they were, California, among other states, were in the second half. But anyway, this was originally released in 2015. So now, about 7 years later, we have almost every state on board. But the elements, essentially, RUFADAA creates a 3-tier system of how your electronic assets can be accessed. So the first is it empowers the asset holder in question. So maybe that's Google, who holds your Gmail account. Maybe it's Facebook, who holds your Facebook account. The custodian of the asset that exists online can create their version of an account manager. If you enter information into their account manager, that is going to be primary. It's like a beneficiary designation. It's going to take precedent over any other estate planning document you have. So a great example is Facebook. You can assign a legacy contact, is the phrase they use, to access your Facebook. You can specifically say, my legacy contact has, these 8 authorities, but they do not have these 6 authorities, or, anywhere in between there. Facebook spells it out between accessing certain assets, making posts on your behalf, like legacy posts. Sometimes you'll see those on people's Facebook pages. And so you can name this your legacy contact as whoever you like. So, for example, if your spouse is going to take over for your everyday financial management, but maybe isn't computer savvy, you could assign this to your child. And that designation would control, even though it is contradictory to who you've named as trustee of your trust, for example. So many companies, especially the larger tech companies, have adopted this. You can go in and relatively easily assign your specifications. And yeah, that's the first tier. If you exercise your authority here, period, you're done. Please make sure it's updated if your wishes ever change, because that is what's going to control. Then tier 2 is, what do your estate planning documents say? Does your will or your trust or your power of attorney give authority to another person to access your digital assets? And what access have you granted? So I would say the default for good estate planners at this point is we are including access to assets. And we're usually doing so in pretty broad strokes. So for anyone who wants to limit what their agent or trustee is accessing, they should make sure that their documents are narrowly applied. If there's something you don't want passed, that should be included, because otherwise the power we're giving now is assuming that you'd want everything that is valuable online. You'd want someone to have access to it. And then if you don't have an account manager assigned through the institution, and then you don't have estate planning documents in place, or you don't have the proper authority in your estate planning documents, then tier 3 is the terms of service, which again, terms of service almost always say, no one but you can own this, no one but you can access this. It goes away after you've passed away, period.
Sure. Okay. That makes sense, which is another argument for why everybody needs a will. A lot of people need a trust. That's just your opportunity to make those designations. Let's say that you have an estate plan in place, and you have your spouse as your primary, your sole beneficiary. Maybe the kids are contingent beneficiaries. Is it good practice to go into Facebook and assign a specific manager, maybe your spouse, if they're already named in the estate plan? Because we see this with like transfer on death assignments on accounts too. You can set your bank accounts up to pass directly to a beneficiary without going through probate. The problem is that kind of supersedes your will, and if one of those things changes, then you have a lot more stuff to go back and revise. So what's best practice here?
That is a great question. And I'm going to leave myself a little bit of wiggle room here, which is this is so new that we're still testing out the best opportunities. But my personal opinion is realistically, if your wishes change, you're not going to update them in 18 places. We've just seen it time and time again. You update one account, but you leave an old beneficiary on another account, right? Everyone knows a horror story where someone got a divorce but did not update everything they owned. And so the ex spouse inherited something. Same thing here. If you cannot reliably assure your attorney or yourself that you are going to update all 10 designations that you've created, then don't do it. Keep it consistent with your estate plan. If there's one exception, let's say it's, let's be dramatic because it's fun to listen to. Let's say that you cheat and you know that there is one account you use to communicate with your extramarital partners. Well, maybe go in and make an assignment there that's appropriate. But for everything that is consistent with your plan, yes, I'd want my spouse to have authority over this. Yes, I'd want my kids, if they're next, to have authority. I would say don't utilize tier one. Use tier one for those special circumstances. I mentioned earlier, and this actually applies in my family. My parents have each other named as agents and trustees for almost everything, but they have skipped over each other and named myself and my sibling as their digital asset managers because we're just more computer savvy. So if there's a unique situation where it should divide, change paths from your other estate planning documents, then address that separately. But yeah, I think don't make more work for yourself.
And we see this over and over and over again. I'm sure in your practice, definitely in my practice, everybody says it's not going to happen to me. My marriage isn't going anywhere. My kids aren't going anywhere, right? It's not going to happen to me. And we sincerely hope that that's the case. But at the end of the day, people get married, people get divorced, people die, people are born. Family dynamics change over time. And there's no reason to create unnecessary work for yourself. Just have all your wishes, all your intentions roll up to one estate plan with a few documents in it as the central nexus of all of that decision making.
There's lots of examples of this, but one of my favorite is Kobe Bryant's estate. Kobe Bryant had 3 children when he created his estate plan, but at the time of his death, he had 4 children. That 4th child was not included. There were these extensive trusts set up for his 3 eldest children, and not for his youngest daughter. And it's, it just is a reminder that your life is changing. Births, deaths, divorce, all of these are going to trigger potential changes in your wishes. So keeping things as simple as that you can, I hesitate to use the word simple because it's not simple, but simpler than it could be. That's usually my recommendation.
So can we define digital assets here a little bit? We're talking about social media accounts, right? When we use the word digital assets, everybody thinks Bitcoin. So you let's say have an IRA or a brokerage account somewhere. That's, you're probably accessing that digitally as opposed to calling a broker on the phone every time you want to make a trade. So where does cryptocurrency fit into this? Because your assets in your IRA and your brokerage account are protected not through RUFADAA, but through what? The probate and your state asset laws?
Correct. So this is such an interesting question because the landscape is changing all the time. So yes, digital assets right now it's a huge umbrella, and I am curious to see whether the umbrella shifts or is split into more umbrellas as life goes on because I believe that for the average person who doesn't have cryptocurrency of some kind, they're thinking something like the photographs they keep online, maybe their Etsy store or their TikTok account. And then cryptocurrency is kind of a beast of its own. However, under RUFADAA, all of those things are included. So for right now, it's your digital assets you may own online, including cryptocurrency, Bitcoin, assets like that. It is the access to more tangible assets. So your logins for your, IRA account, your login counts under RUFADAA, although the dollars are, handled separately. Think of it like a filing cabinet, and there's the cabinet itself, and there's the documents inside the files. And imagine they're two completely different things. And then, like I said, the more intangible social media accounts, pictures, podcasts, other content you are putting online, whether it's, your post on Facebook about that amazing breakfast you had or something else.
Right. Okay. So just to summarize here, logins to access assets includes digital currency, but does not include the stocks and bonds that might be in your IRA, just the login to access them.
Correct.
Did I get that right? Okay.
You did. Mm-hmm.
And it's changing rapidly, it sounds like.
Yes.
Okay.
I think that what fits under the umbrella, it's gonna keep growing. What people own online, the definition is changing. And so I think at some point it will be narrowed again. But right now, almost anything fits under, I shouldn't say almost anything. Almost anything you do on your computer fits under RUFADAA.
Got it. Okay. So what would you say then to the people who are listening to this and they say, I don't really have to worry about it. I still have that spreadsheet with my spouse's username and password. What do we do with the spreadsheet?
Oh, goodness. So
this is your opportunity to say that you need an estate plan in the first place.
Yeah. Okay. So have an estate plan in place. If you're hoping that your spreadsheet will be sufficient, we can just do so much more and protect you so much better through the use of, I'm going to say trust because I am located in California. And so in almost every case, a trust is the way to avoid probate, which in California, avoiding probate is a big factor. But regardless, so everybody has an estate plan. Even people who don't have an estate plan that they created, there's a whole set of laws in place that will apply to you that you may or may not like. But if you haven't overridden them by creating your own estate plan, that's what's going to, carry out your wishes. So, who inherits, who controls, who can access. And so absolutely, you should have it in writing. You should get to decide what you want, whether that's what they can access in your online account, whether that's, if you're leaving access to your kids, at what age can they access? There's so much that you can specify if you put in the time to specify. Otherwise, we could tell you what the generic laws are that are going to apply, and you may like them or you may not. So, yeah, good question.
And this is of real importance from my perspective, right? Because any part of any sound, comprehensive financial planning experience should be just a discussion about what you want to happen with your stuff after you die. And to your point, the state where you live has its own rules and regulations. They're not going to come in and like seize your house and take it away from your family or something like that, right? It will go somewhere. This is just your opportunity to specify your wishes in the most efficient way. And the reason that we care about avoiding probate, particularly in California, is that when you die, if you have assets that go through probate, and that means that even if you have a will, assets that you specify to your beneficiaries through a will still go through the probate court, and a judge has to interpret it and formally assign them to your beneficiaries. And in California, it takes a long time for your beneficiaries to get your stuff. Courts are backlogged. It's public. And it's
You can go online and see exactly who owns what and where it's going if you know where to look.
That's right. And it's super expensive, right? Because in California, isn't it true that your estate has to have representation and they're entitled to like a percentage of the estate or something like that for their fee?
So you don't have to have representation. It is very difficult to do a probate without an attorney, but you technically can. But nearly all the time, the attorney is assigned to an attorney is appointed in a probate. And yeah, attorneys are paid 4% of the first 100,000, 3% of the next 100,000, and essentially 2% of everything after that. The real catch is your debts don't count. And so for, individuals in my situation, let's really simplify my estate. I have a I live in California, so I have a pretty valuable house. I have a decent sized mortgage, and I have a decent amount of student loan debt. So I'm probably, just slightly in the black in my personal life. But when my estate is probated, they're only going to look at the value of my house. They're not going to look at my student loan debt or my mortgage. So let's say my house is worth $600,000, fair market value. That's a probate fee already getting close to $20,000, regardless of the fact that maybe I only have $5,000 in my estate because everything else is going to pay my debts. And yeah, as you say, a will only comes into effect when a person passes away. So if you use a will to say, I leave everything to my kids, what you do is you keep everything in your personal name. And when you pass away, those assets are trapped in your estate until the probate court receives your will and says, oh, these assets are supposed to pass to Hannah's kids, Mary and Jane and Tom. Instead, the recommendation is the trust, which comes into existence now. Let's say I have a trust called the Shakin Family Trust. We don't have to say that. I have a trust called the Shakin Family Trust. And instead of owning my home in my name, I own it inside the trust. The trust has the provisions to make sure that when I pass away, the house is not in my estate. The trustee named in my trust can step in immediately to sell it or refinance or do whatever I have asked them to do inside my trust. So that's, I think, applicable to many states, but certainly California. Probate is a beast, and we would always ask that you try to avoid it.
And it's simple to do, right? I mean, a trust for a lot of people sounds like this, I don't want to set my kids up to be a trust fund baby. I'm not super wealthy. That's not what we're talking about. This is a really basic thing. It might cost you a couple $1,000s to set up. Then you place assets inside of the trust, and then nothing else changes. It's just a really efficient and inexpensive vehicle to avoid probate, which, as we're talking about, is super important.
Beautifully said. That's absolutely what I would want to convey.
So if you're creating these trusts and have estate plans done these days, is it fair to say that any sound attorney who's licensed in California is going to incorporate digital assets as part of that?
Oh, that's a great question. I think yes. I think it has been RUFADAA has been in existence long enough now that even attorneys who aren't actively updating their documents or staying on top of things should have incorporated this into their plan. I do always promote working with someone who is really focused in a particular area. Probably any attorney can purchase a program to, input your name and your kids' names and spit out a trust. But I would always recommend you find an attorney who doesn't also dabble in a whole bunch of other fields, because you do want to make sure they're staying on top of the law. And it's really hard to stay to keep your vocabulary going in a lot of different practice areas.
Yeah, absolutely. So if you're getting a trust done now or have done one recently and it incorporates digital assets, you can safely rely on that document and ditch the spreadsheet, right?
Yes. So
that supersedes tier 3, which is the terms and the agreement basically you have with Facebook and YouTube and so forth. But if you've assigned a specific manager through those platforms, that's going to supersede your estate planning documents, right?
Correct. So if you want to think about the practicality, if I give someone my login, they're logging in as me. So maybe that is sufficient to do what they need to do, but they would be accessing the same thing that I am accessing, which if you're administering someone's estate, what's more practical is to say, I am the legal representative. I get my own login, right? Hannah's trustee gets a login into Hannah's account that is set up specifically for that trustee. So you don't have to worry about getting locked out. You don't have to worry about that dual authentication. You are establishing your own right as the person with legal authority to access that account. It is a little bit, as we've talked about, a little bit limited. We don't want, the institutions assume we don't want our trustee to be able to do all the same things we could do, but at least they have a verified and accessible way to get into the account or the whatever it is that can't be taken away because they're actually entitled to that access.
Do you think you're putting yourself at risk by accessing a deceased person's account using the credentials on the spreadsheet?
The legal answer is yes. There is a law that exists that says you are breaking the law if you do that. I think, practically speaking, people are going to keep doing this in terms of, hey, I need a really quick value as of the date of death. So they'll log in quickly and see what it is so that they know what they're working with. I don't think that's ever going to completely go away. And I think that's probably okay as long as we're not, using if you are using someone else's login who has passed away to log in and move money, that is different. That is not what I'm talking about. But if you are using the login to get a snapshot of what is in the account, I think that that's okay.
Right, right. So what about someone who had their estate plan done 8 or 10 years ago before RUFADAA existed? There's no mention of digital assets in their trust. That's still good? If you say everything to my wife, we
If your
good?
estate plan does not specifically mention that these digital assets, then it is not sufficient for these purposes, and you will fall into tier 3, the terms of service.
Okay. That's good to know. And that's why it's helpful to review this stuff every now and then. And this is something else we hear in the financial planning firm over and over again. Our kids are grown. Nothing's changed. We had it done 15 years ago. Nothing's changed at all. We're good. Yeah, but the laws have evolved around you, and the
Yeah,
world we live in changes.
yeah, the most frequent reason individuals need to change their estate plan is because their wishes change, right? Family changes, you have a new grandchild and you want to leave them a gift. Those things happen more frequently than big significant changes in the law. But big significant changes in the law are also happening around you. So a check-in with your attorney in a perfect world every 3 to 5 years, in probably a more realistic world every 5 to 10. Check in with that person. Say, here's what my life looks like. Do I need an update? How do my documents look? That's always a great idea. This is just too important to say one and done.
Yeah, absolutely. So let's circle back to trust planning here real quick. So we talked about creating a living trust as a vehicle to bypass probate. Cheap, relatively easy, not that big of a deal. In order for that to work, the assets that we don't want to go through probate have to be titled and put inside the trust. We talked about our house. We like to put our house inside the trust. What other stuff goes inside the trust and what stuff does not?
Sure. So it's easier to start with what does not. And obviously, you see this every day, but retirement accounts and life insurance, retirement accounts never go into a trust. Life insurance almost never goes into a trust unless it's a trust specially created to hold life insurance for tax minimization purposes. So let's say we're talking about a normal family, your retirement and your life insurance is not going into your trust. And that's because you get a better income tax treatment on a retirement account if you, a human, own it. So, what your estate planning attorney and your financial advising team should be helping you with is, if you have a trust, updating your beneficiaries to potentially include that trust. Or if we're not including the trust as one of your beneficiaries, when you're going through the process of creating an estate plan, is still a great time to check in, make sure you're happy with the beneficiaries named, make sure you have those named. And obviously, a good estate planning attorney is going to look at everything you own and give you more specific advice on this topic. But that's some general information for the moment.
For life insurance, real quick, we say we don't want to put life insurance inside of the trust, meaning the owner of the policy or naming the trust as beneficiary of a life insurance policy.
So the owner would be the human, the beneficiary is often the trust.
Right. And that's okay, is what you're saying.
Yes, correct.
Yes, right. We do have I started our financial planning firm in Oregon, and in Oregon there's a $1 million exemption for estate tax purposes, and irrevocable life insurance trusts that's a pretty common strategy up there. So if you're a client who lives up in Oregon, we may have something set up, and what Hannah is talking about mostly refers to California, where it's a lot less common. The federal exemption amount is what, 12.5 million, something like that?
12,060,000.
12,060,000. So if you die with less than that, you're not going to pay an estate tax and therefore do not need to use this vehicle we're talking about.
Yes. So you're right. I should specify state to state. So California does not have a state estate tax. So we are only concerned with the federal estate tax exemption, which is 12 million and change. Obviously, in Oregon, if they have an estate tax that kicks in at 1 million, you might be seeing some other strategies. But let's say you're here in California, or you're talking about your main trust and not your irrevocable life insurance trust or other, slightly more complicated tax minimization trust. So for your general revocable living trust, other than your retirement and your life insurance, nearly every other asset can be owned in a trust if the value of that asset is over $184,500. Then it must be owned in the trust, because that is the figure at which probate is triggered. So for almost everyone in California, your house absolutely needs to be in your trust. Even if you go through all the work of creating a trust, if your house is owned in your name, Hannah owns her house. When Hannah passes away, it's going to be in her estate, and someone will have to go to court to get it out of her estate. So property, almost always into a trust. And then bank accounts, we take it case by case, because probably you don't have 184,000 in your checking account. If you do, you should definitely be talking to Grant and his team, because that's not good. That's probably not advisable for your financial planning, but for estate planning purposes, under 184, and this is, I should specify, this is aggregate. So you could keep up to $184,000 outside of your trust. And there are reasons you'd want to do so. Keeping a specific account number, keeping a specific co-owner. There are reasons you'd want to keep your, often your household checking and savings in your name. But then anything of more value, anything that has the potential to grow, we often ask a client to move those into their trust. And when I say move them, I mean retitle them. Instead of Hannah being the owner of that brokerage account, Hannah's trust, the Shakin family trust, should be the owner of that brokerage account.
Yep. And that kind of conversion of titling is something that's really easy to do for brokerage accounts. Every brokerage firm, they do this all the time. They just need proof that the trust exists. You sign a piece of paper and its title's converted. Your house is a little bit more challenging. You have to go to the county clerk's office, I suspect.
So luckily, if you work with an attorney, they'll prepare a deed. They will usually ensure that the deed is recorded and that your home is actually transferred into your trust before you're done. But yes, if for some reason didn't do your house when you did your attorney, or you're doing a new house, you're purchasing a new house, you can ask your title company to put your home directly into your trust. Otherwise, you should visit the recorder.
Yeah. Okay. And what about your business? What about LLCs, S corporations? Do those go inside your trust?
So sort of is the answer. Trusts are not entitled to the same benefits as corporations. There's no liability protection inside a revocable living trust. There's no different tax scheme applied inside a revocable living trust. It is the same as would be applied to that human if they did not have a trust. So what we don't want to do is unwind your business and move all the assets into the trust, because you're giving up a lot of the benefits. But we do want your right, your responsibility, your authority to that business to pass to the individuals of your choosing, assuming you're allowed to do that under your business, your incorporation documents. So I should say, if you have a buy-sell agreement with your partner, that is going to apply. You can't undo that in your own trust. But assuming you have a right to be bought out, you want to pass that to your beneficiaries of your trust. So what we would do is we would either assign your business to your trust, meaning you execute an assignment saying, I assign my right, my responsibility in my LLC, in my stock shares, in my et cetera, to my trust. Or we can actually issue new stock certificates, or you could take title as Hannah, trustee of her trust, is the member, the member, so that you're integrating your trust and your business in one of those two ways.
Right.
Or both, sometimes both.
Yeah. Okay. And so this is where that contingency, and we've talked about this on the podcast and in a lot of other episodes, contingency planning for what happens after you leave your business is deprioritized by every business owner I've ever worked with. It's the last thing anybody wants to think about. You're focused on what's going on today. You're putting out fires. You don't care about your exit plan down the road. And at the end of the day, this exit planning process is just good business planning in general, and it spurs a lot of great conversations with your partners, and it needs to be aligned and congruent with your personal estate plan. So it's a good opportunity to really shore up weaknesses and vulnerabilities in your business and talk about your partnership agreement in general. But it needs to be congruent with your personal estate plan, because it might be just fine to have whatever you want that to look like embedded in the buy-sell agreement, and then have your personal stuff totally separate. But maybe not too, right? I mean, there are so many permutations of this; it's endless.
I agree. And in particular, if you have a family business, inevitably, one child is going to be more involved in the business than another, and both children want to make sure they're treated fairly. So if your business is directly part of your estate plan because that has value, and that is, imagine we're creating an estate plan and your wealth is your home and your value in this business you started, your kids are going to be really invested in how you divide, how you distribute things. So, especially in that case, we want to make this one big conversation. We don't want to do these piecemeal because there's just too much implication on what your trust says. And I will say that here at Downey Brand, we have a robust trust and estate litigation department, which means, I try my best to avoid the family fights and make sure you've thought through everything. But if that's not the case, and brother's going to sue sister, or they're both going to, whatever the case is, I could certainly tell you some stories another time. They'll go to court, they'll fight these fights. And so the best thing you can do is make sure your wishes are written out, make sure they're clear, make sure they're well thought out, because ambiguity is when you open the door to litigation. So don't leave room for them to say, well, mom would have wanted this. No, I know mom would have wanted this. Just tell them what you want. They may not like it, but at least they knew it's what you wanted, and you've highly, highly reduced the likelihood of, litigation existing because of your passing.
Yeah, and that gets into the concept of having family board meetings and that kind of stuff to align all this and open the lines of communication. We had a really good guest on the show. I'm trying to remember his name, Stephen Short, I think, maybe 6 months ago, who's an expert in family succession planning within family business. And the framework that he comes up with was super helpful. And I can't remember the name of his book, but if our listeners are halfway interested, go back and find that episode, because he had a lot of good things to say.
That sounds wonderful. Yeah, I went to a similar continuing education conference on that topic earlier this week. And yeah, one of our activities was thinking through, okay, what are the questions that the non-involved family members would be interested in, and how can you, head those off? And what about the members of the family who are actively involved in the business? And, everyone is going to be most concerned with whether or not they are treated fairly. So don't let that question fester. Just address it head on.
That's right. That's right. Are there any common mistakes you see business owners making over and over and over again in your estate planning practice? Is there anything that just comes up all the time that people ought to think about?
So this is not limited to business owners. This is, I would say, among all of my clients, whatever the question is that they're thinking through. People really want everyone to get along after they pass. And the way they think they're going to accomplish that is naming the oldest child as the person in control. But they're the oldest. They would expect it. Their feelings will be hurt if I don't name them. I cannot say strongly enough, being someone's trustee or executor, it is a job. It is not an honor. Do not pick the person whose feelings you're trying to avoid hurting. Pick the person who is most competent, who has the best relationship with the individuals involved, who will clearly communicate what's going on. Don't name all your children to work together. That almost never works. I will allow my clients to name two individuals together if they have a good reason. And I will push back here and say, why are you naming two? Do they really need two? Is one person going to do all the work? And if so, what is it that you're hoping to accomplish? I almost always try to steer clients away from naming more than two. I've seen 6 kids named as co-trustees, and there is not a scenario in the world where that would work out well. It just wouldn't. So I would say that's the biggest, whether you're taking over the estate or the business or some combination thereof, who you pick to be the person in charge, it might be the biggest decision you make the whole time. Who gets what, that kind of all works itself out. Whether you choose, your kids will get it at age 30 or age 35, that all shakes out in the wash. But who's in control? Who decides how the money is spent, how the money is invested, whether or not they keep the house? Anyway, that's comes up again and again.
That's a very good takeaway. It's a tough decision for people because these are tough conversations to have as a family unit, right? But they're important, and there are a lot of families out there who wish they had them before it was too late. So something else I wanted to ask you about before we wrap up today is so we talked about using trusts. We've talked about assets going into the trust versus staying out of the trusts. One tactic we see really commonly for families with minor kids is you don't want to put your retirement accounts inside the trust, right? That negates the tax benefits. The account already passes by contract, right? So you name beneficiaries. If you name your spouse as the beneficiary of your IRA and your kids who are underage as contingent beneficiaries, if you're in a car accident with your spouse, what happens to that asset is it goes into conservatorship, right, until your kids are the age of majority, which is 21 in California. Is that right?
So
18 or
for
21?
IRA distribution purposes, it's 21.
It's
Yes.
21. So
Yes.
what that means is the kids, when they hit age 21, inherit everything. And even if you put assets in your trust and specify that they're to receive half of the assets at 25 and then the other half at age 35, or some way to split it up to where they're a little bit more mature and they don't have this huge party where balloons fall from the ceiling and kegs of beer come out and all that stuff. When they hit the age, one thing that I hear over and over again from attorneys is to name the trust as contingent beneficiary of the IRA. Recently, we have had some changes to the rules that inform when we have to take money out of IRAs. It was called the CARES Act in 2019, I think. And now, whereas we used to be able to stretch out distributions from IRAs over the rest of your life, meaning if you inherit one, you can take a little bit out every year in perpetuity, now a lot of people are subject to this 10-year rule, where you don't have to take any money out the year after you inherit the IRA, but you do have to clear out everything from the account by the end of 10 years. And that's not quite as tax-friendly to you and me and other people who might inherit IRAs down the road.
Right.
So
I mean,
how
it's
does
very important to remember these are pre-tax dollars. So the whole reason that people care about this is whenever money comes out of that account, tax is paid. So if you get to take a little bit out at a time for 60 years, that usually is a small tax each year. But if you have to take out everything right away, that's a big tax. And yeah, as Grant's saying, now you have this 10-year window usually, but go ahead with
how do
tax.
trusts come into play here? What happens if you name the trust beneficiary of your IRA?
Sure. So it is going to depend on the type of trust. For these purposes, your revocable living trust often falls into one of two categories, and one is what's called a conduit trust, and one is an accumulation trust. And I would say most of the time we're talking about what I would call conduit trust, meaning interest is passing. Anything coming into the trust will eventually make it. I don't want to get too deep into the weeds here. So if I have a trust that says the income is going to pass to the beneficiary, and then at certain ages, more is going to pass out, that's a really probably a poor explanation of a conduit trust, but let's just say we're in that window. Then you're going to get to use whatever laws would apply to the underlying beneficiary. So for adult children, or for most of the people who will inherit from you, they have the straight 10 years to take the money out, whether that's 1/10 over 10 years or everything in year 10. Work closely with your CPA and your financial advisor to strategically take this money out. Although I have heard a statistic that something like 65% of inherited IRAs are cashed out within the first year. So we would love to see that number change. Regardless, when it comes to minor children are allowed to take required minimum distributions, meaning a minimum amount based on the calculation of that child's life expectancy. So let's say your child is 10 and the government says they have a life expectancy of 72 years, then they're going to get to take out 1/72nd of that account. And the next year they're going to take out 1/71st of that account. And they get to do that until they reach age 21. and then 10 additional years, meaning until age 31, they're taking out the minimum amount that any person would be allowed to take out. And then they have to take out everything. So again, strategically, you may take out more than 1/70th of the account because that child may be in a low tax bracket and you may want to take out slightly more to get a better tax treatment. But you don't have to. No one else gets that benefit. So you can accomplish this lower tax treatment by leaving it directly to the minor child, but know that the risk is that child may not be mature enough to make the right decisions. Or you can leave it into your trust. Your trustee, who's an adult that you've handpicked to carry out your wishes, can use their, smarts, their intelligence to make the best tax decisions while still getting the benefit that your child is entitled to, meaning the stretch out until age 31. And of course, those stretch out, that's all for the benefit of your child. Your trustee is not benefiting from this. They're just the decision maker.
And if it's inside the trust, once you die, that revocable living trust then becomes irrevocable. Is that right? And
Almost always,
so
yes.
if you're taking money out of the IRA that the trust inherits, there are tax consequences that we're talking about. And there's a lot of tax strategy and ways to minimize the amount you have to fork over to the authorities, which we generally like to do. But the money that comes out would be taxable at the trust's tax brackets as opposed to the minor child. Is that right?
Great question. If structured correctly, the goal is it's being taxed at the child's tax rate.
Aha.
So the way we accomplish this is the money has to be coming out of the trust. So for the child, directly to the child, for the child's benefit. Let's say that your required minimum distribution this year is $11,000. We would want to spend that $11,000. We want to send the kid to camp, buy them a car if they're of that age. We want to get it out of the trust so that we can have it taxed at the child's tax rate. Because if we don't take the money out, if we just leave it inside the trust, it is going to be taxed at the trust tax rate. And for context, trust hit the highest tax bracket at, I believe, 13,000 and change dollars. Humans aren't going to hit the highest tax bracket until I think it's about 500,000 right now. So that's a 37% tax, either on the $14,000 that you earn, or not until $500,000. So we really want to try to shift that.
That's exactly right. Trusts pay they have the same tax brackets that you and I do. It just only takes $13,000 of income to get to the highest bracket. Individuals have much wider brackets, and so we can spread that taxation out and want to tax to the individual as opposed to the trust wherever we can. What if we take money out of the IRA and put it in an account in the name of the kid as opposed to the name of the trust? Does that sufficiently get it out of the trust? So we don't have to spend the $11,000. We just have to get it out of the trust, put it in a different account.
Correct.
Okay, got it. Okay. Great. This might be a little bit too technical for some of our listeners, but I think the takeaway is that estate planning is a big deal, and it's something that nobody likes to think about or talk about. It always gets pushed to the back burner for a lot of people, but this stuff is important. And the general concept is we're trying to get our assets to our beneficiaries in the most efficient, cleanest, fastest way that minimizes taxation. And there are so many opportunities to do that if you just put a little forethought into it and work with a specialist like Hannah.
Yeah, thank you. I agree. I think that, the actual content of information we're talking about today, it's probably hard for the average person to remember all the things that we just discussed. But the point is, these benefits are out there if you know where to look for them. So if you're working with the right team, I think occasionally I'll have clients who are a little bit frustrated because I ask for a lot of information, right? Account statements and all their goals and everybody's names and birth dates and all kinds of information. But the point is, it's because I'm trying to accomplish what we've talked about today, minimizing taxes, getting as many benefits as possible. So yeah, I would say it can be tough to get an estate plan set up. Don't be frustrated if there's a lot of questions. There's usually a big long questionnaire that comes from the attorney. They're interviewing you. It feels very personal, but the goal is there's so many benefits we can try to grab for you if we know that that's one of your goals.
Yeah. Well put. And I might add too, all your team of advisors, your accountant, your financial person, your attorney, all need to be on the same page. And it makes it a lot easier when they are, right? Because you don't want everybody working in silos. You want them to share the vision of what you're trying to accomplish. And when it comes time to create the estate plan, it's pretty easy to just say, Hannah, you have my permission, go give Grant a call and he can share what our balance sheet looks like. It's stuff like that. Just makes it so much easier for you and far more likely that your intentions and expectations are going to be met.
Absolutely agree. Plus, it just ensures that extra layer, those extra eyeballs. I've had clients who, go through the effort of creating their estate plan, and then this was a little bit before everything was online. This person went to their bank and did a beneficiary designation form the way I had instructed them to do it, but they did it on the wrong form. And so what they didn't do was actually update their beneficiaries. They did it on a form that applied to a completely different kind of account. And so that beneficiary update was completely invalid and we weren't able to use it, and it created all these problems. And so what I know is if someone's working with Grant or with someone of his skill level, then I can reach out to the financial advisor directly and say, here are the updates we need to make. And that they'll be carried out. Because unfortunately, there is homework after your estate plan's created. There are things that need to be updated. And if you know that you have an educated set of eyeballs looking at that update, we can just avoid any possible pitfalls.
Yep. Well put. So, Hannah, I want to be respectful of your time today. Excuse me. Let's wrap this up. Where can people get a hold of you if they need someone to review their estate plan or they need one drawn up?
Sure. So,
and you can direct them to the website to call. You don't have to give your personal email out if you don't want to.
My email is just very long. But so I work for a company, Downey Brand, DOWNEY. Brand is BRAND. Or you can, just Google me. I promise there's no other Hannah Shakins out there. So if you Google Hannah Shakin, and that's SHAKIN, you will find my bio on the webpage, and you can feel free to. My direct line is there, as is my email address. I am only barred in California, so I'm happy to weigh in on other issues, but really California-based questions are where I'm able to offer the most assistance.
Right on. Well, this has been really educational. Thank you for sharing some of your wisdom. I learned a lot. I hope our listeners did too. And we'll have to do this again sometime down the road as all the rules change again a couple of years from now.
Thank you for having me. Thanks for the wonderful questions. And I can't wait to talk to you again.
All right.
Thanks for tuning in to Grow Money Business, the podcast dedicated to helping business owners grow both their wealth and business on their own terms. Be sure to subscribe to the podcast on iTunes, Google Play, or wherever you digest podcasts to ensure you don't miss out on future episodes and announcements. And feel free to submit questions to growmoneybusiness.com.